they will determine the nature. Just it's hard to imagine, of course, our regime without the political parties because they are integral to almost everything that's happening in terms of the governing apparatus. So one thing that wasn't quite clear in the very beginning was the political character. Political parties will arise to clarify that in a very quick way. Another thing that was very unclear, so here's another unanswered question, was what was the Supreme Court? And it's not just the Supreme Court, it's like the entire judicial branch. So I always think of things in physical form. So we have Article 1, which deals with the House, with the Congress. It's pretty big. And Article 2, it deals with the executive branch. It's pretty big. And then Article 3, which deals with the judicial branch, it's really small and very vague. And the reality was that almost nobody knew, exactly what's going on here. There's a lack of clarification. And indeed, to show us, the second act of our government, so this is, here comes Congress to get going. Here's the House of Representatives. Second thing they did, I've always wondered what was the first thing. And this is me just being stupid, but the first thing was dealing with lunchtime and bathroom breaks or something like that. But the second thing they're going to do is called the first Judiciary Act. And that time, of course, it was simply called Judiciary Act. But we call it the first because there will be more. And this will be passed in 1789 as the government is just starting. And the intent was to try to clarify parts of the judicial branch, especially the Supreme Court. And so they come up with this law, which is really problematic. They create 6 justices for the Supreme Court. And I hope you guys see the essential problem with 6, and that's an even number, creating the potential for a tie as they're making a decision. But it wasn't just that there were 6 justices, but they're also to ride the circuit. So that meant that each one of them had their own circuit somewhere in the United States. And so they weren't even around each other. They were their own independent entity riding their own independent circuit. So you could actually come up with 6 different decisions as far as the Supreme Court was concerned. A very untenable situation. And I have to tell you that the vast majority of people who were approached to become members of the Supreme Court didn't want to do it because they couldn't see the value in this. It just didn't seem to make any sense whatsoever. Well, we finally get to 1800. It's going to take a long time to work all this stuff out. And there's going to be 2 significant developments, and I thought I had a card for them. I'm sorry I didn't. One of them, and this is at the end of the Adams administration, is the second Judiciary Act. So they're going to try to fix what they didn't quite do right in the first one. And this time they decided that there should be 5 justices. So we're not to our 9 yet, but we have at least 5, and that's an odd number, allowing for the potential, of course, of one side to dominate, win in every particular situation. One side that will affect the decision. And then the second thing that's probably just as important was that the Supreme Court would stay in Washington, D.C. as the highest appellate court. So the cases would come to it rather than it traveling around looking for cases or something like that. So they're changing the nature of the court, and that becomes really critical to dealing with it. Just as important, though, was in the same year, Adams, in an effort really to kind of preserve the power of the Federalists, will appoint this man by the name of John Marshall to become the Chief Justice of the Supreme Court. And John Marshall will become just a critically important figure. He was sort of a country cousin of Thomas Jefferson and others. He was from Virginia, but he kind of grew up on the frontier. One result of this was that he was a very, I guess you would call him, rustic dresser, and not really very careful or mindful of his appearance. In fact, he kind of looked like a bum, to be honest with you. And there's a famous anecdote of John Marshall walking home in Washington, D.C. from his day at the Supreme Court, and some woman, asked him to carry her groceries home for her. And of course he did it, being a polite individual. And then she tried to pay him, of course. And she probably never even knew that the Chief Justice of the Supreme Court had carried her groceries home for him. But John Marshall will be appointed, begin serving in 1801. He will be the Chief Justice of the Supreme Court for 35 years. And he was a very wise and able and ambitious individual. And so John Marshall will begin to shape the Supreme Court into a meaningful role. John Marshall is often called the father of the Supreme Court. And of course, it's a very appropriate title for this individual with a huge impact. What he will do is he will begin to manipulate cases that will come to the Supreme Court. And there are things like Marbury versus Madison, McCulloch versus Maryland. And the primary thing is that, he began to affect the power of the Supreme Court, what the Supreme Court can do in these particular cases. And the power of the Supreme Court that will begin to emerge is what we call the power of judicial review. So that means that the Supreme Court will have the final say on the laws of the United States of America as to whether they fit or do not fit the Constitution of the United States of America. So by having these cases come forward, by using this idea of the constitutionality versus the unconstitutionality of the law, John Marshall began to shape what really becomes a huge power of the Supreme Court. The Supreme Court did not have any kind of clarity in the very beginning, but once Marshall is done, it will have a profound power. Do understand the power of their decisions, right? Dred Scott, is a decision made at the end of the antebellum period that, suggested, for instance, that you could take your slave wherever you wanted into the free territories, of course, massively antagonizing the North and leading to the rise of the Republican Party heading towards the Civil War. Plessy versus Ferguson, this critically famous Civil Rights Landmark Act, of course, that said that while the Constitution does guarantee equality, it does allow for separation, and of course this will lead to universal and comprehensive segregation across the entire South. Then 1954, Brown versus the Board of Education, reversing that, right? That there is no place for segregation in the public schools of the United States, and the call for desegregation with all deliberate speed. Miranda rights, Roe v. Wade, the power of Citizens United. I have to tell you that, that's just, in my estimation, that's horrible. All of a sudden, basically liberating the wealthy individuals and entities to support as much as they want, of course, political campaigns. These things have a powerful, powerful meaning. And we also need to understand, of course, that justice is not blind. It's tremendously political. And that means that when you have chief justices who are of a liberal bent, or you have justices of a conservative bent, that can really shape things that impact America. Right now, we have a court that perhaps might. It's hard to imagine they could overcome all the precedents that might reverse Roe v. Wade. I'm not going to tell you that is going to happen, but it's intriguing that there's a lot of momentum in that particular direction. So, taking away this fundamental right over their bodies that women have had since the 1970s. So, I don't know where that's going to end up, but just to show us, of course, the Supreme Court and the power of judicial review is essentially important. Unclear once the Constitution is implemented, clarified very significantly over the next course of it's a long period, 30, 40 years. They'll really begin to figure out exactly what the Supreme Court is all about. Now, there were some unanswered questions that were actually ultimately dangerous. So here's one I want to highlight for you guys, and it's the issue of states' rights. So the question is, what are the rights of the states relative to the federal government? Just a quick lesson in states' rights. One primary issue is that the states preceded the government. In fact, the states preceded the United States of America. They were the very first independent entities. So just the fact that you're first is always going to be really important. And I made a big point at the beginning of all this of how the states are fundamental, right? It's the name of our country. The flag designates the states, of course, all those kind of things. So even though there is a constitution, the states are very critical. The states voluntarily consented to the Constitution, of course, and that becomes part of it. And the rights of the states are actually designated, or at least suggested in the Bill of Rights itself. Number 10 says, it says, the powers not delegated to the United States by the Constitution nor prohibited by it to the states are reserved to the states or to the people. So, it's a vague statement, but it basically says, states do have rights. Now, the question is, what are those rights? And it's in some ways an enduring kind of question. So, here's a little bit of an offing, or situation in the offing. We have an issue of states' rights, and that could become a problem. And it does become a problem, so that's why I want to highlight it really quickly for you. The first time it became a significant problem was in the 1830s. And in the 1830s, the federal government passed a tariff. So a tariff and it was the highest tariff ever. A tariff is an import duty on goods that are being brought into the United States of America. And the state of South Carolina decided that tariff would hurt them. It would damage their economy. So they decided to evoke their state's rights by not adhering to that law. So they called it nullification. So they basically said within their rights as a state, they have the right to ignore a federal law that would do them damage in this particular kind of way. Now, of course, they're saying that they don't have to abide by the tariff, and Andrew Jackson was the president, said, yes, you do, and South Carolina said, no, we don't, and Andrew Jackson said, yes, you do, and this goes on for a long time until they actually began to mobilize a little bit for conflict, Andrew Jackson mobilizing the army and South Carolina mobilizing their state militia. And that became what we call the nullification crisis. Oh my God, where is this going to go kind of thing. Now, luckily, calmer heads prevailed. The decision was to negotiate the situation. They lowered the tariff, and South Carolina agreed to pay the lowered tariff, so they got over that particular hump. But it kind of shows, that something could go wrong here. If If they hadn't resolved that, that could have led to violence way back in the 1830s. Now, the second major expression of states' rights occurs in 1860. And in December of 1860, it became clear to the state of South Carolina that Abraham Lincoln was going to be elected President of the United States. And not only that, but the Republican Party would dominate both houses. And Lincoln and the party were avowedly and openly anti-slavery. And, of course, if you're in the South, that's going to look bad. And the South Carolina decided that they would evoke their states' rights. And one thing that I think is intriguing is like everyone believes in the Constitution, but of course they're interpreting it in their own particular way. And South Carolina believed that they had voluntarily consented to join the Union, so they had the right to voluntarily leave the Union in what became known as secession. And South Carolina will do this, I think, on December 20th, 1860, to be followed by a number of other southern states, of course, which will form the Confederacy and create the foundation for, the coming of the Civil War. So it shows you how dangerous states' rights could be if these are not clarified in any kind of way. And indeed, this one particular question of states' rights will lead to monumental violence, the rendering of the nation as far as the Civil War is concerned. So unanswered question that proved to be very problematic. And then finally, one other truly problematic unanswered question, and it has to do with the issue of slavery. And so the question is, how does the Constitution deal with slavery? And the answer is with the highest level of ambiguity. I mean, it doesn't help the situation at all in terms of the question of slavery. So here's what the issue is. The Constitution, on the one hand, very much supports slavery, in fact, in numerous situations. While they never use the word slavery in the Constitution, it's clear that it's upholding slavery. The 3/5 rule has to do with slavery. The importation issues, they will not stop the importation of such persons until 1808. That's about slavery. There are issues kind of running away from contract, that's about slavery. I think there are 5 or 6 different places where slavery is and the issue is evoked essentially. So the Constitution absolutely, supports, doesn't necessarily guarantee, but absolutely supports slavery in no uncertain terms. So on the one hand, the Constitution supports slavery. On the other hand, the Constitution also, in a subtle way, denies slavery. The Northerners didn't want the word slavery in the Constitution, so they don't allow it. So you have these awkward constructs, that representation will be based upon Indians not counted and 3/5 of all other persons. If you're coming from Mars, you haven't a clue what the hell's going on here, but everyone there knew that those persons were indeed slaves. And the importation of such persons, and again, everyone there knew that they're talking about slaves. Slaves are the only people imported to America. Nobody else gets imported. So, the Northerners decided they didn't want that ugly, what they considered that kind of ugly word to be part of the Constitution. So you see both sides here. On the one hand, support of slavery, on the other hand, denial of slavery. And so the answer is, what does the Constitution do about slavery? It doesn't do anything about it, right? It leaves it kind of an issue in abeyance. And of course, it's going to leave future generations to have to confront this particular issue. And let me just finish this little section with something from Thomas Jefferson. Late in life, and I think this was actually in the 1820s, Thomas Jefferson has a nightmare, and he wakes up, and Jefferson was keen, of course, to record all of his thoughts and everything like that. But he wakes up with, sweating bullets, of course, because he had these terrible nightmares, and he writes, "I dreamed I heard the knell of union." So the bells are tolling for the union. That's what happens like when somebody dies. The union is dying. And he says that, he writes this down, he says, "I fear we will be the murderers of our children." And the reason he's saying this is because he's kind of thinking, our generation, the founding generation, has not dealt with slavery. And so we've left it there just hanging out there, and future generations will have to confront this, of course. And the sad thing, he's pretty prescient here. I mean, they will be the murderers of their children, because their children will go to war in 1861 in the Civil War. And somewhere between 600 and 700,000 people are going to die in that war. So it's not necessarily untrue. But certain things that the Constitution will confront and deal with, of course, but there are problems that are left in abeyance, which will become hallmarks for the future. And with that, I will finish my section on the creation of the American Republic. We'll see you next time.